Yes, Mr. Phillips.
Yes, my lords. May I go back to bundle CB3, page 741, which is the amended notes, and I was just about to turn to the confirmatory note, and I don't know if your lordships are keeping open the numbered version, but that's a matter for your lordships.
It's totally suggested we should, so I have.
Grateful, my lord. So phrase 17, the confirmatory note. The notes are intended to have a right to a return of assets in the winding up or dissolution of the issue in priority to the rights of the holders of any securities of the issue which qualify, or save when non-qualification is only due to any applicable limitation. The reason for that is that in regulatory capital, even if you have instruments that technically qualify for particular levels, there are limits for how much of each type of capital you can have. So that's what that's referring to. And it says as upper tier 2 capital or tier 1 capital, with the respective meanings given in GEMPRO. So it explains that the notes rank above upper tier 2 and tier 1 capital, and they were, as you know, lower tier 2. So it's identifying where in the waterfall, as it were, of regulatory capital debt you find them. And I am going to show you a little later that one reference I've mentioned. So,
I think you told us that this qualified either as level 2
or tier 3.
So how can it rank above tier 1?
That was the sub-debt. It's lower tier 2 or tier 3. It goes up tier 2, lower tier 2.
Oh, I see. It's reverse order. So
it's reverse order.
Yeah.
It's actually, tier 1 is shareholding. It's the most permanent form of capital.
Of course.
And as you go up,
it
drops in number. So the LBHITs, the subnotes are stated as being intended to have a right of return of assets in the winding up in priority to the rights of the holders of any securities which qualifies up tier 2 or tier 1 within the meaning of GEMPRO. Those are the more permanent forms of capital in LT2. Of course, my lords, your lordship see, it's the words in priority are used. They are similar to the words over, which we saw in phrase 10 and phrase 16. And of course, my lord, your lordship immediately asking, sorry, why does it go 3 up to 2? No, it shows you why in regulatory capital they do tend to count from the bottom up. That's what they do. And you can see why they've done that. The conditionality deals solely with the position over or in priority. The other important point to note is that the word here is any. It's any. It doesn't say some up to 2 securities. It plainly means all of them. And what the note envisaged, which was consistent with Mr. Miller's evidence, which you've got references to, of market practice, was the following waterfall, which is unsubordinated creditors, dated subordinated creditors, which is lower tier 2, tier 3, sitting above undated subordinated creditors, which is upper tier 2, including the notional holders, as we've seen them set out, and ordinary shares, which is tier 1 capital. That's what the notes remain lower tier 2 debt because of the type of instrument and the subordination. And that, of course, was confirmed by Allen and Overy to Lehman's in their advice. And consistent with this waterfall, it was expressly envisaged that it would all sit above the upper tier 2 debt, and all the upper tier 2 debt, not just upper tier 2 debt that used the notional holder mechanism, which is where the learned judge landed. And we say the confirmatory note is important. PLC argues, and the learned judge held, that the notes are subordinated to all upper tier 2 debt except the upper tier 2 debt using the preference share dealing mechanism, which is not consistent. but that is not what the confirmatory note says. It plainly refers to subordination in priority to all upper tier 2 debt. It's also consistent with the definition of senior creditors, which excludes claims that rank or are expressed to rank junior to the subnote. And that carve-out is not just limited to subordinated debts using a preference share mechanism. And the confirmatory note is a very clear expression of the party's intention that the subnotes should not be treated as equity. And my lords, your lordships have the point as to the reasons for that, and that they should sit above the equity. And by sitting them above the equity and introducing the assumption that 100% of principal and interest was payable, the amendments were able to address the tax concern. PLC now relies on the hypothetical preference share construct to suggest that the effect of the amendments was to subordinate the notes to the level of equity. That is the opposite of what the note states. Which
I'm not sure they go that far, do they? I think they would accept that it's above the level of equity because it's still a debt, but it's ranked right at the end of the queue.
Absolutely at the end of the queue, apart from entities.
Apart from what you might call real shareholders. Apart from real shareholders.
Yes, and that is not what that says, and it might be a convenient point for me to just take you, if I may, just briefly to investors' compensation scheme, so that I can just explain where we think this fits in legally. It's in Authorities Bundle 121. It's just 388 in the Investors' Compensation Scheme case that I'm sure is very familiar to you all.
You've read it
The
before.
passage that I just wanted to refer to is in 388, and it's the passage at the bottom at 913H to 914A. And if you'd be kind enough just to refresh your memories of that, and then I'll make a very short point.
So sorry, could you give me that reference again?
It's on page 388.
388, thank you.
And internal page is 913.
Yep.
Grateful.
Yeah.
And the point that we make is that in the context of a recital, what Lord Hoffman says is that he thinks one should start with the assumption that a layman reading the provision, the explanatory note, and didn't venture into the claim form was being given an accurate account. And that's what we say in relation to this. In our submission, the judge should have started with the assumption that the confirmatory note was accurate and construed the confirmatory note as stating that the LBHI2 subnotes continued to rank above all securities qualifying as upper tier 2 capital, which is what it says, including all upper tier 2 debt. And he should then have noted that his conclusion was to the effect that all upper tier 2 debts rank above that the LT, the subnotes. His conclusion was they rank above the subnotes, except those which used the preference share dealing mechanism. That was the judge's conclusion, which was inconsistent. And if he had started with the proposition that the note, the explanatory note, was accurate, he should have looked at the conclusion that he was reaching and considered, well, can that really be right? And in our submission, for other reasons which your lordships have, we submit it wasn't.
I mean, ICS was concerned with an arrangement with householders.
Yes.
So with, as Lord Hoffman puts it, laymen. This, on the other hand, is a tradable financial instrument. You would expect somebody to go into a high street bank and buy some. I mean, there are also cases, are there not, involving pension schemes where an explanatory booklet is issued, and the courts have consistently said, well, that can't take priority over the rules.
No, it's a question of what you do with it. One
Yeah.
starts with the proposition, this should be accurate. And I'm going to briefly say something about Mr. Miller's evidence in due course. I don't want to go out of course on that. But you should start with the proposition, well, that should be accurate. And then test the conclusions that he had reached against it. And at that point, he should have realised that a conclusion that the notes were subordinated to all debt, including all up to tier 2 debt, unless it used that share mechanism, was questionable. Put it no higher than that, and then one gets into the other submissions which you've already got.
So you would say the exponent, this note is a warning device, and actually no more than that.
A warning device is something that you should start. Yeah, I think that's a fair way of describing it. I'm not saying that if the language had said something clearly that was different to the explanatory statement, you would overrule the clear language with the explanatory statement. Not at all. But you've got a statement which you should start with the proposition that that is an accurate statement. And from there, one can test the conclusions which the judge made. And well, I think it's a convenient moment to turning to the judgment on the notes. So if we could just get up C2 22 414. And it starts at 218, and you can see that the first matter he turned to was the confirmatory note, and he said that in 220, I will construe the provisions of condition 3A, but in light of the explanatory note, and of course any other relevant background. And in our submission, that's not what he in fact went on to do. And then picking it up at 221, so that you can see now his approach. This in our submission is where the learned judge made a key error, because what he says in 221, he refers to the amendment, says that they are significant, and he says, speaking in the broadest of terms, I'll seek to construe condition 3 more narrowly in due course. Condition 3A contains, as a result of the modifications, 2 regimes, and this is central to the learned judge's approach regarding the subordination. One regime, that described from phrase 8 onwards, which is the conditionality referred to above, which applies where the following condition is satisfied, and he then refers to the insolvency condition, if I can put it that broadly. And another regime, that described from phrase 2 onward, which applies where this condition is not satisfied. So in our submission, the learned judge was wrong to hold that there were 2 regimes that were entirely distinct. And as we go through the judgment, your lordships will see that that is precisely what he did. And you have our submission that to say that the one regime that applied in an insolvency was from phrase 8 onwards, from the conditionality, was with respect wrong. We say that, and I think I've made this point, the language, the conditionality referred to above, can't refer to what we call phrase 2, but the subordination phrase and the definitions, which you have seen. So moving on to 222, where he deals with the second regime, which is applicable where the condition is not satisfied, is in all essential respects the same as that which applied in the unamended notes. The first regime, applicable where the condition is satisfied, is new. It will be necessary to consider the nature of the new subordination regime. And if we can then go over to 226, paragraph 226 on page 4 and 6 in the bundle, where he says, it is unnecessary for me to consider the second old subordination regime applicable where the condition is not satisfied. He then explains why not. And then he says this, and this is very important in the learned judge's reasoning. Accordingly, this section considers only the first subordination regime, which begins at phrase 8. And in our respectful submission, that was a serious error. Because
this is the so-called solvent regime.
I'm sorry.
This is the solvent regime. 8.
Which begins at phrase 8. No, this is the condition. Phrase 8, just for the avoidance of any doubt, my lord, because this is important. Phrase 8, which he is there referring to, starts with the language, if at any time an order is made by a competent court.
Yeah.
So it's the insolvency regime.
It is the
insolvent
insolvency
regime.
Yes, my lord. And so what the learned judge did, and I'm sorry, I hope I'm not being too putting it too forcefully, but we think this was a serious error that then runs through. What he did was he separated out that new amended conditionality, and he put aside or did not refer to the definitional language that you've got in phrases 2 and the definitions. The language, the rights of the note holders against the issuer in respect of the notes are subordinated in right of payment to the senior creditors as defined below, on the learned judge's analysis, is no part of the regime in a liquidation or administration. And with respect to the learned judge, we respectfully submit that was wrong. In our submission, the further conditionality, if we call it that, the phrase 8 on, the language, cannot be construed as a standalone subordination provision, free from the language of the other parts of that clause that your lordships have been looking at in the amended clause 3. And if I could just, forgive me if I'm going too quickly, but if I can just then look at 228, where this is what the learned judge, he went on to construe phrase 8 and following, and you can see it when he says, the first part of the clause, brackets, phrase 8, simply reiterates the condition that serves to trigger this part of the provision, which is also found in phrase 7. The clause proper begins at phrase 9, where the condition pertains, as I find it does here, the note holder is entitled to payment determined by reference to what are, in effect, new terms. And with respect, I'm sorry, but that's wrong. They're amended terms. They are not new terms. And as I've said to your lordships, and forgive me for repeating it, but it is such an important point, the learned judge took no account of the fact that phrase 2, that language I just read to you, is still in this clause. And it is the only language, as I hope I've shown you, that ranks the subnote below other debts. That's the language that says you rank below these other debts. And then if I can go forward to 229.1, because the learned judge turns to the characteristics of the hypothetical preference share, he rightly noted the further conditionality adopted the notion of a hypothetical preference share, and he says it ranks above all other classes of issued shares, although phrased in language alien to subordination above rather than below. All this provision does is make clear that the rights of note holders do not fall below those of any shareholder. In short, the provision limits the extent of subordination. I doubt very much whether it would be legally possible subordinate the debt below shares, but in any event, this provision makes clear that the rights of note holders rank just above shares. Well, we respectfully agree where he says the provision limits the extent of subordination. We respectfully agree. We've got the subordination, and now it's saying you're not going below this level. However, having correctly noted that the language of above and over is alien to the language of subordinating a debt, the judge then went on to construe those words as subordinating the notes below particular debts. And if I can pick that up at 229.2, where he says it ranks above the notional holders. The notional holders is a term defined by phrase 15 as any creditor of whose claim against the issuer and winding up quantified as though they held a notional share. Then he deals with the definitions of the notional holders, and he notes in A the notional holders were creditors, but he didn't go on to consider the effect of a provision that ranks these notes above even some creditors, because that's not what he ended up concluding. And of course, the effect, one effect, is that if you rank above creditors, you cannot rank in the level of the shares, and that's trite company law. And then in B...
Sorry, I haven't followed that.
Oh, I'm sorry.
The judge's interpretation is that they rank above other creditors whose claims are quantified as if they held a notional share.
Yes, and only above those creditors. That's where the
Yes.
learned judge ends up.
He's not saying that they are shareholders. And,
He's not.
and to know whether there are any such creditors, you would have to examine every single instrument that whichever company it was had issued to find out whether there were any creditors who fell within that description.
No, well, the reason why I made that point wasn't a criticism of the judge as much as reflecting a submission that was made, which may or may not be made before your lordship. So I'm sorry, I wasn't intending to say the judge made a mistake there, but I think, my lords, you've got the chain of reasoning that you've got a note which identifies that you rank above certain creditors, so we know you can't be a shareholder. You've got the same note that identifies you rank below certain individuals, and that part of it doesn't change. The judge didn't look at that part of it. He only looked at the bottom up and said, well, you've only referred to these individuals, so you must rank there. And that just doesn't follow, with respect.
Yeah. Well, the judge has in effect said, I look at the waterfall as described in Nortel and Waterfall 1. I see that at the bottom of the list are the shareholders. These notes are meant to rank above shareholders. That's all they say. Therefore, they're at the bottom of the queue of creditors. That's essentially how he reasons it.
Yes, although there is one type of debt underneath, as your lordship knows. But that's not how this subordination clause works. This subordination provides that the rights of the notes are subordinated to the senior creditors, as with all the other instruments we're looking at. And the fact that there are some individuals below whom they can't fall doesn't affect that. And even if there was a gap, it wouldn't affect that at all. And the learned judge has just looked at the one and ignored the other, which is the operative subordination provision.
So what you're saying is he has noted the flaw and then has become mesmerised by the flaw and hasn't seen that there is a ceiling also.
That is precisely right, Monet. Sorry. And then if I could move on to 230. He refers in 230 where he says in the second sentence, it seems to me that this provision is more naturally seen as a case of simple contractual subordination, albeit using the device of a deeming provision to define the level at which a note holder's rights are subordinated. The provision is not a form of contingent debt subordination. There is on examination no contingency discernible. And the reason why I'm drawing that to your lordship's attention is that one ends up with a very surprising result, is that outside an insolvency, you have a hybrid provision, whereby you've got what he describes as simple contractual subordination in the first part, followed by contingent debt subordination in the second part, and that's outside of an insolvency. But inside an insolvency, on the learned judge's analysis, you've only got simple contractual subordination in that condition. And with respect, that is a surprising analysis. And then if I can go to 231, because this is where one sees his critical conclusion, where he says, according to this provision, the rights of the note holders rank above all shareholdings, but below all debt, including subordinated debt, except for debt that has a subordination provision similar to the deeming provisions used by the note holders themselves for the purposes of subordination. So he says you rank below all debt apart from the debt I can identify in what we could describe as the floor to the subordination provision. He says the subordination provision thus altogether fails to qualify its relative priority in relation to claims that are subordinated by methods other than by reference to a notional share or the holder of a notional share. It simply subordinates the rights of note holders in such cases to the position of a preference shareholder, which with respect is quite a muddled way of looking at that. With the benefit of hindsight, might be regarded as surprising. And he considers it in the context of rectification. I should say, however, I regard these subordination provisions as unequivocal. It does not appear to me that this meaning is gainsaid by the recital. Well, with respect, we disagree. Set out in phrase 17, but even if it were, I do not consider I could abandon the very clear meaning I found in the subordination provision and so on. And the learned judge then went on to apply his three-step approach. I'm sure you've picked up on the three-step approach. He applied it to the amended subnotes, and the critical step is in paragraph 237, when considering whether claim B was an excluded liability in claim A. Because as your lordships know, the three-step is you look at one from the point of view of the other, you then look at the other from the point of view of that one, and then you see. Okay, you've got the point. What the learned judge said is, according to new provisions governing the amended LBHO2 subnotes, the ranking of the note holders is determined by reference to the hypothetical notional holder. The subordination provisions in Claim B operate by deeming the rights of the note holders to rank as if they were holders of hypothetical preference shares, thus ranking above all shares but below all debt, including subordinated debt. The note holders rank above all shareholders and also above any credited claims are quantified as though they held a notional share, but otherwise rank below all other forms of debt, including subordinated debt. That is the effect of the deeming provision stipulating that note holders are paid as if a preference shareholder. And then in these circumstances, the liabilities of LBHO2 under Claim B are expressed to be, in my judgment, are junior to the liabilities of LBHO2 under the subdebt agreement. Short, they are excluded liabilities because they rank junior to the subordinated liabilities in any insolvency of the borrower. And the reasoning is that because of that amendment, which identifies that notional shareholder mechanism, they've expressed themselves to be junior to the subdebts. And that's the learned judge's reasoning, and with respect, that's not right. So if I may draw this together and make 6 points. In fact, it's 5 because I've already made one of them. First, my lords.
Sorry, just before you go on, you've criticised the judge for not paying attention to the non-insolvent regime.
Yes.
Or the non-solvent provisions. You haven't looked at them either yet. And I wondered what, if anything, you wanted to say about the definition of solvent in little b, it is. Oh yes. In B, for the purpose of condition 3A above, the issuer shall be solvent if it is able to pay its debts as they fall due. Is there anything you want to say about that?
We are going to come to that in a second. I dealt with it in my unamended notes, but I was going to come back to it. But if it would help your lordship, we'll come.
Well, you can come to it when you want to, as long as you cover it.
Okay, I'm told it's better, so forgive me. So if I may just make the 6 points for your lordship's note. Can you give me the exact note paragraph numbers on that, please? First, my lords, we say that the learned judge was wrong to distinguish between the old and the new regime. Secondly, the conditionality that we have been looking at does not alter the identity of the senior creditors. The correct starting point is the identification of below which senior creditors each instrument is subordinated. The amended conditionality in the note does not, construed properly, alter the legal characteristics of the defined class of senior creditors. And you don't discover who your senior creditors are by applying the conditionality. You look at the defined terms. Of course, the defined terms might take you into the conditionality, but they don't in this case. Third, the further conditionality does not impose a ceiling, only a floor. And the judge's central conclusion that the rights of the note holders ranked below all debt, including the subordinated debt, was unsupported by any reasoning at any stage. As the judge said, the hypothetical preference share concept made reference to the subnotes ranking above notional holders and issue shares. He provided no explanation as to how this language could result in subordination below all debt. And a conclusion that debt described as ranking above some specified other debts cannot be construed as an agreement that ranked below. Below all other debt is a logical leap that the learned judge didn't explain in our submission. And that is particularly so where the very same subordination provision identifies the debts below which the subnotes will rank. And in the present case, the debts below which the subnotes agreed to rank was the senior creditors, as defined. And the judge's conclusion is inconsistent with the definition of senior creditors, which does not subordinate the subnotes to all subordinated debt, as, my lords, you have seen. And in our submission, ignoring the definitions altogether was an error. And fourth, the learned judge was wrong to find subordination at the preference share level. We've discussed that particular point. And finally, the learned judge failed to give proper consideration to the surprising commercial consequences of his findings, which, as you know, are that outside of winding up, the LBHI2 subnotes rank above the subdebt, and then the company goes into liquidation or administration when subordination might be thought to be its most important, and the opposite position pertains. And absolutely no one has thought of any rational reason why that should be the case. What would you have? Sure. Can I just pick up a point on the effectiveness point, which was one of the points I was going to have dealt with earlier. Sorry? Yeah, which is the proper approach. If I could then, so I'm switching from this part of the discussion into the proper approach, which is the ineffective principle, because I didn't address you on it earlier, which I would have done otherwise. So if we can go back to paragraph 152. And this is where the learned judge accepted, as regards the subdebt, that it was engaged in an infinite, never-ending race to the bottom. Personally, I can't say that I'm too bothered about races or pushing up and pushing down or any of the above. You've got two provisions, each of them say that the other is senior debt, and that creates a problem. And then paragraph, if we could just pick up PLC skeleton, C1 tab 8 at 123, just page 123, so you pick up this point, and paragraph 68. In that paragraph, PLC also appears to agree that on a textual analysis, the subdebt is involved in a race to the bottom as a result of the definition of narrow definition of subordinated liability. So there is, it contends, however, that by virtue of the solvency conditionality, the subnotes somehow fall even further behind. So we've got acceptance that you have this race to the bottom. In other words, the subdebt can't prove. But then you come into a question of whether or not the subnotes fall further down. We would just draw your attention to the curiosity of such an argument, because as we pointed out at trial, and I give you the notice, paragraph 243 of our submission, if each of the three subdebts is engaged in an infinite race to the bottom, such that none of them are able to prove at all, because that's the consequence, until the other two have been paid, and it cannot be right that the subnotes somehow rank behind the subdebt. Rather, the subdebt and the subnotes both fall to the bottom, and none of them can prove on that analysis. So if the subdebts go, in the judge's words, to the bottom of the waterfall, it doesn't follow that they are senior to the subnotes. Just wanted to make that point. And I now just want to move on to the importance of independent construction, which in the judgment, which is in C2 22-398, so just paragraph 175, which is where he deals with where the rival creditors have both subordinated themselves, matters more complex, and he says it's impermissible. An impermissible approach would be to read the subordination provisions in some way conjunctively, and that methodology identified is then repeated when he deals with the three steps approach. So the judge's view, which we respectfully agree with, is you have to construe them independently. What you can't do is you cannot look at the one in order to construe the other. You have to turn from one to the other.
So you agree with his subparagraph 1?
It's impermissible, yes.
Right. Do you agree with his subparagraph 2? It may seek to rank itself by reference to other obligations.
No, I don't.
So that you say is wrong.
Yeah.
And what about 3? Possible for two subordination provisions in different instruments to reach inconsistent outcomes.
That's correct. I agree with that.
You agree with that? So the flaw, you say, is in his subparagraph 2.
Yeah, and particularly the way the learning judge applies it. You should look at each instrument independently and answer the question from that instrument. Is there an expression of juniority in that instrument when you then turn to the next instrument? But what you can't do, and what the learned judge did, and you've probably seen it on a couple of occasions, is that he flipped from one to the other. But I don't want to expand on this too much because this is relevant in the unamended. Okay, so yes, just to explain what an independent three-step construction looks like. You take the first instrument and you take the second instrument, and you read them side by side. Step 1 considers the ranking of the second instrument in the first instrument, assessing it against the different defined levels in the first instrument to see where it ranks. Step 2 considers the ranking of the first instrument in the second instrument, assessing it against the different defined levels in the second instrument to see where it ranks. And step 3 considers common outcome or resolves any security. That's, in our submission, how it should be done. Sorry? So that was ineffectiveness and independent construction. And what we submit is that if the judge had construed the amended notes correctly as being subordinated to the senior creditors as defined, but sitting above the notional holders and issued shares, the exercise he would have carried out would have been as follows. So we take the two agreements, you take the one agreement and you see how the other relates to it, and claim A and the amended claim B do not cross-refer to each other in any way. They simply do not talk to each other. Both instruments are in place to further the same regulatory purpose and are lower tier 2 or tier 3 capital. And although the starting point is not significant, say you start with claim A, you ask yourself whether the amended notes are an excluded liability in claim A, and on a proper analysis, there is nothing in claim B which suggests it is junior to claim A. The further conditionality, as you've heard, only addresses the position over certain obligations which do not encompass the LBHI2 sub-debt. The senior creditor's definition is in substance materially the same as that in claim A. Next, claim B is not a subordinated liability in claim A. Claim B, therefore, rises to the top of claim A as a senior liability. You then look at claim B, and you look at where claim A falls within claim B. Again, there is nothing in claim A which suggests that it is expressed to rank junior to claim B. It does not express itself to rank pari passu with claim B. In fact, it doesn't cross-refer to claim B at all. Therefore, it does not fall into any of the carve-outs from the definition of senior creditor. It is therefore a subordinated debt that doesn't fall into the carve-out, and claim A rises to the top of claim B as a senior creditor. And that leads...
Sorry, just say that last bit again. You say nothing in claim A says it's junior to or pari passu with claim B. It's not within...
It's not within any of the carve-outs that we see in claim B in the definition of subordinated creditor. The carve-out is carve-out of senior creditor, and it's subordinated unless. Apologies.
Therefore, it's a senior creditor.
Therefore, it's a senior creditor. So you have got each one of them.
Just a minute. So that means that looked at in terms of claim B, claim A is a senior creditor.
Yeah.
Right?
And looked at,
and therefore claim B should be subordinate to claim A.
No, they're both senior creditors from the perspective of each other.
No, I mean, yes, but I thought you said that claim B rose to the top, and that's when I lost you.
Oh, I'm so sorry. When I say I'm so sorry, I was doing it independently. So I was analysing claim A first of all and saying claim B rises to the top. I was then doing the same with claim B and then saying, so claim A rises to the top.
But I thought you said claim B rose to the top second time round.
No, I'm so sorry.
Right.
No, that was, if I did say that, I misspoke, and I apologise.
So each in terms of the other is a senior creditor,
Yes.
and the tiebreaker is the rule.
Well, the tiebreaker is neither of them effectively subordinates one to the other. The judge, learned judge, describes it as ineffective, as between the two of them.
But what's the contractual? I understand if the rule breaks the tie, but what's the contractual principle that you apply?
they do not contractually subordinate to the other. There is, in order to subordinate a debt, the creditor has to express themselves as subordinating themselves to another debt.
Yeah.
Otherwise, they will prove at the same time they will rank pari passu. So whether one wants to describe that as the tiebreaker being the rule, or whether one wants to say that is because they do not effectively subordinate one to the other, neither of them subordinate, you're in the same position as A1, A2, A3. The judge described that as ineffectiveness. That's ineffective subordination is the way I understand it. And we also have an alternative case, which, if I may, you may have picked up from our respondents' notice that we have the alternative case, which is what I would describe as insolvency-centric, perhaps, as opposed to contractual-centric. And I'm not sure, my lord, that you will find much favour with it, but let me please...
Well, I don't know. I mean, the trouble is that on your analysis, both Claim A and Claim B do effectively subordinate themselves to the other claim.
To the other...
That's the problem. They very clearly
they can't.
Quite. So,
and that's why the learned
so you've got to get out of the impasse somewhere.
Yeah.
Either you do it because there's some contractual principle that you can apply, and I'm not at the moment sure that I understand what it is, or it's the rule that says that unless you've done this very clearly, we have to apply a pari passu distribution. And that bit I can understand, but I'm struggling a bit with the contractual principle to apply. If, as you say, each of the two claims does, looked at in its own terms, effectively subordinate itself to the other claim.
Which is an impossibility.
Well, if you can find the contractual principle, I'd be very happy.
Well, the learned judge did it on the basis of ineffectiveness, which you've seen, which is that you cannot have subordination between two instruments where they each purport to subordinate themselves to each other. It's just not possible. The alternative case, which for your notes is at pages 46 to 49 of our skeleton. Our alternative case is a simple case, but the fact is these instruments do not talk to each other. They have the same, materially the same definitional structure. They identify the same senior creditors, the same category of junior and subordinated, but it's the senior that matter. If a series of debts, because the one thing you can't realistically expect, particularly in the real world, is that there will be a complete contractual regime across all debts. And so what you've got is you've got debt that subordinates itself to the same senior creditors. That entitles each of those creditors to prove in the liquidation at the same time. And they will therefore rank pari passu. And that's how we developed it at trial. And that is our respondents' notice case. That's our alternative case. And I've explained it quickly, but it's a relatively simple 46 to 54 and 58 to 68.
Sorry?
46 to 54 is the unamended, where we deal with it in the context of the unamended notes, and 58 to 68 is in the context of the amended notes.
Right, this is in your skeleton.
Yes.
You're giving me paragraph numbers, are you?
I am giving you paragraph numbers,
yeah.
My Lord. Looking at the time, I think I'd be very hard pushed to actually expand on this in great detail now.
Yep. Right.
And also deal with rectification, which I've still got to deal with. So
yes.
If you will accept my apologies. The point is, before your lordship, and your lordship may come up with a better answer. I don't know. You've got the judge's solution, which is that can't be right. Therefore, I will go with what he described as the ineffectiveness principle, where you don't have effective subordination one to the other because you've got them going like that. And you have got our alternative case, which is if they have subordinated themselves structurally to the same group of senior debts, senior creditors, they will prove at the same time And of course, that involves you concluding that they did not treat the other as one of those senior creditors.
Yeah.
So that's the problem, and I acknowledge that's the problem.
Yeah, well, I'm always a little bit suspicious of when with one bound he was free type solutions.
The problem is, my lord, that unless there is a leap and they are made free, it's a real conundrum.
Oh, I agree.
And many of the greatest minds, if you don't mind, my friends, they've all been addressing this.
Yeah.
But we can all see what the right answer is.
I mean, it's perhaps some mileage in the principle. I forget quite where it comes into the wider scheme of things, where the parties have failed to provide for a certain contingency, and where then objectively the task of the court is to work out what they would have done had they, so to speak, thought about it. And here they've thought very hard about subordination, but they've just failed to realise in this particular circumstance it leads to an impasse. So they've effectively left that part of the analysis incomplete. And looking at it objectively, I think you would say the only sensible solution in that circumstance is pari passu, and that must be objectively the intention one imputes to them. I mean, something along those lines.
My lord, not for now, but there is something along those lines in the PLC debate.
Yes. Yes, and I know it comes
don't
in
wanna-
somewhere.
I don't want to take
I've
it.
forgotten just where, but I just wonder whether it might
if I may.
provide a leg up here.
Sorry. There were just. Sorry, I apologise that this is slightly busy at this point, but I just wanted to say, tell your lordship about two things, and it's interesting because when your lords have been asking, well, what would anyone have thought about it? There are 2 points, and that is when you're asking, your lordship incidentally have already seen Golden Key, and you've seen that one would, if necessary, imply a term into a contract. There are 2 other things. The first is there was the evidence of Mr. Miller, and we accept he was not giving expert evidence. Before anyone gets upset about it, he was not giving expert evidence, but he was a senior capital markets lawyer stating his belief, under cross-examination incidentally, and repeating the advice of A&O to its clients, set out, for example, in a briefing document, which we dealt with in our trial skeleton. And whilst PLC are dismissive of Mr. Miller's evidence, they do say in paragraph 9 that they accept that what Mr. Miller said sensibly enough was what he would expect instruments with lower tier 2 and tier 3 to rank, so he would expect them to rank pari passu by default, which was his evidence. And we, of course, don't disagree that ranking ultimately depends on what the contract says, but the fact that pari passu was regarded as the default for LT2 and tier 3 is material background. And if I could take you to supplemental bundle 1.8 at page Sorry. Sorry? Yes, I'm so sorry. Authorities bundle 5. I gave you.
Yeah, Authorities bundle 5.
It's tab 78A.
Working paper number 12.
Yes, this is the Board Committee working paper number 12. I referred to it in answer to one of your lordship's questions earlier, and I should show it to you. If I could show you 2521.
Yeah.
Tier 3 capital consists of fixed maturity, SND with subordinated debt with a minimum maturity of two years. Tier 3 debt is not amortised. It ranks pari passu with lower Tier 2 debt. Tier 2 and Tier 3 capital does not exceed Tier 1 overall. So remember I told your Lordship that there were different, you could have certain proportions of different types of debt. But the important point is that in the Basel working paper, Tier 3 debt is described as ranking pari passu with lower Tier 2 debt. And you will see that lower Tier 2 debt is described generically. And of course, my lords, the sub-debt instruments that you have been looking at are the standard form that are produced by Basel. And they certainly have recorded there what they think the ranking is of lower Tier 2 and Tier 3. So it all lends support to a pari passu construction. Where is it? I'm going to move on to rectification. Before I go into rectification, we have to just think about the starting point, because either there was a change, if we were right, from a pari passu construction to the notes being junior. Having been pari passu, they go to junior. Or if the learned judge was right, they go from senior to junior. And my learned friend, Mr. Beltrami, in his respondent's notice, is running a case that the notes were junior in their unamended form. Now, I haven't dealt with that because that was part of the unamended notes. But if it's not inappropriate, may I offer to deal with that now, notwithstanding it is in the...
Just to clarify the rectification. The sequence of events is that Allen and Avery makes some amendments to the terms of the unamended notes. Somebody then spots a tax problem. The notes are further amended to deal with the tax problem, which then goes through all the various people in Lehman's who sign it off. And the rectification sought is not to tweak the provisions dealing with a tax problem, it's to remove them completely.
Absolutely.
That, I'm bound to say, goes far beyond any rectification case I know about. But it's not a question of changing what you've deliberately inserted. It's a question of removing everything that you've deliberately inserted to deal with a particular problem, leaving that particular problem now unresolved.
Yeah, there wasn't a problem.
Well,
but
I don't think the judges found it was all illusory, and that there really wasn't a problem.
There are a number of steps in that description, which, with respect, I will deal with. Starting with
it's just that it does raise one's eyebrows to see the extent of the rectification that you are pursuing.
Yes, well, it's a number of things that were done in order to deal with a particular problem, and nobody intended to do any of it. So let me deal with it. And the other,
nobody intended to do any of it.
Nobody intended to deal with the tax point. I need to develop this properly, if you don't mind. And one of the things that, of course, you won't necessarily yet be aware of is that this is very similar to the pensions cases because there is a mechanism for amendment. But please let me deal with that.
Of course.
Sorry? Okay, so can I deal with the point that I referred to, which is my learned friend's point, that the solvency conditionality, which I think was the point your Lordship just raised about 10 or 15 minutes ago, and I promised to come back to, which I am now doing. And in their Respondents' notice, they argue that the judge ought to have concluded that Claim A had priority over unamended Claim B. And the case centres on the contention that the solvency conditionality in the amended Claim B modifies the definition of senior liabilities subordinating the sub-notes to all debts, without exception including Claim A. And just so that you know the history, that didn't make an appearance in the original position paper, but at trial, somewhat surprisingly, it was my learned friend's only case. The core proposition is that the conditionalities on these agreements have a freestanding effect to the definitional part of the provision. And having heard that that is how the case was put, one can understand why the judge made an error. If I can start with C1, bundle C1, tab 8 at 106. And it's paragraph 22, which is the nub of the point, where they say, whilst the first element, namely the statement that the rights of the lender are subordinated to senior liabilities, if a loan might well operate to effect subordination when it is coupled with the detailed subordination mechanism comprising the solvency condition in paragraph 5.1, that first element may properly be regarded as a statement of introductory or general intent. The second element is the critical and implementing provision, which creates and defines the subordination of the debt, and it is through the mechanism of the solvency condition that the subordination is given effect. That's the nub of the submission. And if you note paragraph 39, just looking at the third line from the bottom, where they say the distinct and operational cash flow condition in the LBHI2 subnotes as an expression of juniority enables both agreements to reach the same outcome under both simple contractual subordination and junior debt subordination. Now, PLC are not reading the subordination provisions, as in other words, the whole of clause 3 or clause 5, but in this instance, clause 3. In a unified way. The case on the respondent notice depends on reading the conditionalities as modifying, not unifying, the subordination definitions. And if I can just take you through to paragraphs, just looking at 38 and 39, first it said that the cash flow condition dictates subordination to all other debts, because it says lower than any other debt. If you look in 38, 4 lines down, that's what they are saying, lower than any other debt, as opposed to the senior creditors. And second, it said that the cash flow condition subordination is in of itself an expression of juniority, which you've seen. Now, there are 7 reasons why this is wrong, and this is the point that I wanted to get to. First, and I think it would be helpful for us to get up it would be useful for us to get up and I'll work from the amended the subnotes, which is your Lordship's knows in CB3 at 42, page 741. There are 7 reasons.
Sorry, just a minute. We're going to bundle 3.
Bundle 3.
Do you want the judges?
Tab 42.
Do you want the judges' numbered phrases, or are we just working from the?
I'm just working from
right.
the neutral one.
From the unamended ones?
No, amended.
Amended.
I'll do it from the amended because I understand the point your Lordship has made in relation to amended and unamended, and it's fine. For this purpose, it's absolutely So the first point is conditions 3A, which start on 741, and 3B, which starts on 742, should be construed together. Condition 3A identifies to whom the debtor has agreed to subordinate its rights. And you've seen that SLP has agreed only to subordinate its rights to senior creditors as defined below. And the subordination cannot be to both the senior creditors, but also to all creditors. It can't be on the same clause. And PLC's construction ignores this key inconsistency. Secondly, it flows from the use of the word accordingly, which makes it very clear that the solvency conditionality in 3B, which is the solvency conditionality, is part of the overall mechanism or means for implementing the subordination to the senior creditors. According, your lordships have seen, accordingly, it is not doing something different or introducing a new and further subordination provision. If it was doing something different, the notes would not have used the link word accordingly. Third, if we go over the page to 742 to look at condition B, if we look at the first 6 words up to the comma in condition 3B, for the purposes of condition 3A above, comma, they refer back to condition 3A. They make it plain that the solvency conditionality that follows is intended to give effect to the subordination provision in 3A. Fourth, so you can see that the language used is that the issuer shall be solvent if 1, it is able to pay its debts, small d, as they fall due, and 2, its assets exceed its liabilities, each is defined below, and then in brackets, other than its liabilities to persons who are not subordinated creditors.
Who are not senior.
Senior. Oh, so sorry. And the fourth point we make is that debts with a small d is undefined. It is not used elsewhere in the notes, but it can also, only mean debts to senior creditors against the backdrop to condition 3A. Fifth, the words in parenthesis, which you see at the end of line 2, other than its liabilities to persons who are not senior creditors, make it clear that solvency in condition 3B is only concerned with all debts and liabilities other than to persons who are not senior creditors, which of course makes absolute sense in the context of this provision. Sixth, our construction renders condition 3B little 1, which is the cash flow element, is able to pay its debts as they fall due, and condition 3B2, which is the balance sheet element, which is its assets exceed its liabilities, consistent, so that neither takes into account liabilities or debts that are not owed to senior creditors. Otherwise, the two aspects of the solvency condition would themselves be inconsistent. And what I mean by that is LBHI2 would need to show that it could pay all of its debts on a cash flow basis, including all senior and non-senior liabilities, to be solvent in accordance with 3B1. But it would only need to show that on the balance sheet basis, the issuer's assets exceeded its senior liabilities to be solvent for 3B2.
Is that necessarily surprising? I mean, the application of the cash flow test and the balance sheet tests in ordinary insolvency can produce different results.
It's not a problem that the cash flow and the balance sheet tests produce different results in terms of can you pay your debts as they fall due, as you know from Euro sales, that's in the near future,
Yeah.
and do your assets exceed your liabilities. Where it is a problem is what the debts or the liabilities that you take account in the context of both of those, what they produce as an answer. And if one of them refers to all debts and the other one only refers to senior liabilities, that is a tension that, with respect, I do think that is a problem. Yeah. And one has to read this in the context of a provision which is subordinating the notes to the senior debts or the senior liabilities. And one has to ask, what debts or liabilities are you expected to be able to pay before you're able to pay the subordinated debt? And the answer to that must be the senior creditors or senior liabilities that you have agreed to prove after. And that's the context in which this provision arises. And that's why we say debts in this context can only mean senior debts due to senior creditors. So,
One more reason.
and that was just one more point, which is that if debts included both senior and non-senior liabilities, then in our submission, the solvency condition would be unworkable, not least because even if a debt were expressed to rank junior to the sub-notes, so you've got an express juniority in a sub-note, it would need to be paid before the sub-notes became payable because it's a debt. So you would have another debt that ranked junior to the sub-notes, and under this condition, if debts means all debts, that's got to be paid before you could pay the subordinated debts, which by definition are senior to that junior debt. And what that means is that it would alter the identity of the debts to which the sub-notes are expressly subordinated, because you'd have to pay the junior debt first. So those were our submissions on the solvency condition, and as to why, and the reason why I did this at the beginning of the rectification cases, as to why the sub-notes were not junior to the sub-debt. That was the point I was making. So, turning to rectification, and I've heard everything that your lordships have said, and I hope I will deal with all of that. We have got on the judge's analysis this difference as to how the sub-notes rank before and after insolvency, and you've also got after the insolvency they rank, outside of an insolvency they were senior, then inside an insolvency they were junior, all of which are, if I may respectfully put it, just surprising surprising conclusions. And we've referred to that as the ranking alteration. But the reason why it's important is that on the judge's analysis, and even if we were right and they ranked pari passu prior to amendment, the amendments that were made, and we'll come to the purpose of them in a moment, but the legal effect of the amendments was to make these sub-notes that had either been pari passu or senior, junior to the sub-debt. And we will show you that the reversal of priority is inconsistent with the oral and documentary evidence. That shows that the sole alteration of the parties' legal rights which the amendments were intended to effect was a deferral of the payment of interest. And the parties did not think, nor were they told, that they were making any alteration to the parties' legal rights other than the deferral of the payment of interest. There was no need to alter the ranking of the sub-notes to achieve the deferral of the payment of interest and to deal with the potential tax issue identified by Allen and Overy. Now, PLC seek to downplay the significance of the deferral of the payment of interest, and they refer to it variously as the origin of the amendments or the core commercial purpose of the amendments, with the implication being that the parties intended to make other fundamental changes to their legal rights and obligations. But as we shall show your lordships, whilst it is correct that the parties intended the amendments should protect, as opposed to make changes to, the LT2 regulatory status and the tax status of the subnotes, the only fundamental change to the legal rights and obligations intended by the parties and needed to address Miss Dolby's tax purpose was the change to the interest payment date. And that, incidentally, we would leave. We weren't intending to change. There was...
No, I understand that, but I just find it quite difficult to follow on the facts. Mm-hmm. Certainly, when the process of amending the document started, the purpose was to defer interest. It's difficult for you to say that remained the only purpose, given that Allen and Overy spotted the tax problem and Lehman's were content to accept whatever it was that Allen and Overy drafted to deal with the problem. They didn't say, hang on a minute, all we want to do is defer interest. What are you doing mucking about with the terms of the notes? That wasn't their reaction. So you've got to accept, I would have thought, that there was a deliberate intention, well, not necessarily intention, there was a deliberate acceptance of the words that Allen and Overy inserted in order to deal with a perceived tax problem. And those are the very words that you now want to take out by rectification.
Yeah, no, they wanted, I will show you the material, but they did not simply say, Allen and Overy, whatever you want to do. And they were very clear about the purpose, and they wanted to protect the subordination status. So we'll look at it. This is absolutely not a case, and I put it to Miss Dolby, in which they said, oh, Allen and Overy, do what you like. It's absolutely not that case. So I understand your lordship's point. I understand. And we're seeking to take out a lot of words, but there are a lot of words that shouldn't have been put in. And there is no principle why you can't, if 20 words are used to do one particular thing.
No, I'm not saying that it's a number of words that matter. It's that the fact that they were deliberately inserted for a particular purpose, and if they are removed, that purpose will no longer have been served.
Oh no, it will, because there are the deferral of interest is all dealt with, and there was no need for anything else. But we'll see that.
The tax problem, the judge made no findings about that, did he? That this tax problem was illusory?
Yeah, there are two different tax problems. Do you want me to explain?
Well, you take it in your own time.
No. Let's Sorry. Which page is that on? Sorry? Point 6. No. The two different tax problems. I'll come back to the tax problems.
Yeah, all right.
Oh, no, I won't. I'm so sorry. There were two, it's very important to distinguish between two different tax concerns. Dolby and the tax team's objective was to amend the subnotes to provide the ability to defer the payment of interest. And that would lead to tax optimization. And that was the sole intention behind the amendments by a relevant decision maker. So that was the tax question that had given rise to the instructions and the need to amend. In contrast to that, Allen and Overy, who did not know that Lehman's had received extensive tax advice from PwC at the time the subnotes were issued, had a separate concern, with regard to the solvency condition, which they never shared specifically with Lehman's, Mr. Dayhow believed that the solvency condition appeared to make the payment on the notes conditional on LBHI2's results, and thus that HMRC might view the subnotes being more like equity than debt in a winding up. It was a completely different concern, and that might jeopardise LBHI2's ability to use the subnotes interest expense as a tax deduction. A&O's internal solution was the replacement of the solvency condition with the preference share conditionality, which we have been looking at, which included the specific assumption as to the notes and interest being payable in full. So as we go through this, please just have in mind there are two distinct, although they're both tax problems, two distinct tax problems. We say that there are 5 grounds which we have advanced, and they are in C1, A3, 27 to 28. What I want to do, if I may, is start with the legal principles, which I'm sure you're very familiar with, and then proceed into the judge's findings of fact and some other fact material. So can we start with what the judge said about the law, which is in C2 22425. And it's paragraph 258, and in particular, so he deals with the rules of common mistake, and in particular in paragraphs 3A and B, where he says on page 426, as regards the provision or aspect of the instrument to be rectified, there was a common continuing intention in regard to that particular provision or aspect, and secondly, there was some outward expression of accord. And just going back at 257.3, the learned judge acknowledged that some instruments, the rules of employee pension schemes are an excellent example, contain specific provisions regarding their own amendment as the terms of the notes do here. Such provisions can affect the rules regarding rectification. The point that we make, and I will expand on it, is that the learned judge did not then apply that principle to this particular facts of the case. The logical starting point is that it is more likely that parties who make a specific amendment to an existing contractual arrangement will have the requisite actual common intention not to alter the rest of a pre-existing contract, save in the specific respect in which it is intended to amend it. That's the logical starting point. And that is because prior to the amendment, the parties to an existing contract intend that their rights and obligations are those set out in the existing contract. After an amendment, the parties intend that their rights and obligations continue as set out in the contract, save for any changes that to those rights that they intend to make. And two closely related principles can be derived from the case law. In some respects, they are different sides of the same coin. For your lordship's note, we've got them in paragraph 93 of our skeleton. First is this: where an existing contract is amended, if it can be shown that the relevant decision makers had an intention only to make a specific and limited change to an existing contractual arrangement, if we call that change X, then it is convincing proof that the decision makers did not actually intend to make a further legal change Y. The second proposition is that where change X has been the subject of extensive preparation and discussion and advice, but change Y has never been discussed at all, the absence of any discussion about why is likely to be compelling evidence that the parties did not subjectively intend it. Can I take you to AMP and Barker, which is in Authorities Bundle 1, tab 24, at 455, please. And if you could turn to page 458, which is when the judgment of Lawrence Collins, as he then was, starts. And if you could cast your eyes over paragraph 1, please.
Paragraph
1.
Paragraph 1. Yeah.
Yes, my lord. There's a handful of paragraphs. I'm just going to show you. The point of this is just so your lordships are aware, it related to a pension scheme of a company called MP1, and it involved an amendment to increase incapacity benefits. And if I may as well explain that early leavers were treated as if they were leaving due to incapacity. And so when they increased the rights of people with incapacity, it accidentally increased the rights to early leavers as well. But if you could look at paragraph 3, please, where it explains that the trustees and the members of the board who approved the rule changes, they'd overlooked that fact. So that was the mistake. And then, if I may take you to page 470, paragraph 66. Just read the first sentence. There must therefore be cogent evidence of the intentions both of the trustees and MP1, but not necessarily their agreement or accord. And if you could...
Sorry, where are you? 66?
66, first sentence, my lord.
Yeah.
And then that's picked up in 67, which, if I may just read, consequently, what AMP has to show convincingly is a continuing common intention by the trustees and the MPI to effect only incapacity benefits. It's clear from the factual findings that there is overwhelming evidence that their intentions were limited to improving the benefits for those leaving on account of incapacity, and they had not the slightest intention to benefit early leavers in general. So that is what they were intending. And then paragraph 71 on page 471. Again, if you could cast your eyes over that paragraph. And my lords, please note where Mr. Justice Lawrence Collins says it's quite unreal to contend that the intention of the trustees and MPI was simply to pass a resolution containing the words which it did in fact contain. Nor can it be said that they intended simply to sign anything which was put before them. The resolution was subject to preparation, advice and discussion. It was not the result of a rubber stamping exercise.
Can you help me about this, Mr. Phillips? What is the rectification that was being sought? In this case?
Is very lax of me. Can I come back with that? I do apologise. I should have worked that out.
On one view,
yeah.
If one applies this to your case, or rather if it applies what you want to do to this case, Mr. Justice Lawrence Collins would have struck out the increase in benefits for the incapacitated, but I don't suppose he did.
No, no. I mean, not if you did what we're talking about.
No.
Being
So
because
he's not saying he's not saying, well, you didn't intend this amendment to have this side effect, therefore we'll remove the amendment.
Oh no, I'm sorry, my lord. There's some confusion. We're not intending to remove all of the amendment.
Oh,
just the conditionality.
Well, the one to dealing with the tax problem.
No, the one that's dealing with Mr. Dayhal's tax problem.
Yeah.
The amendments that deal with the deferral.
I follow.
Interest,
You want those to stay in?
Yeah,
Yes,
we
I
want those to
understand.
stay in. So it's specific to that. So in this particular case, they would have. One would expect. Have you found it? One would expect that they were taking out the amendment or they would have been dealing with the amendment that meant
linking incapacity to early leaving, something like that. Yeah.
Something like that. Can I return on that? The team's looking. But the point is, in the context of an amendment to a pre-existing scheme, it was sufficient to show common continuing intention only to affect a change to incapacity benefits, and that the decision maker did not need to advertently apply their mind to the benefit to early leavers in general and positively consider it was not the change that they intended. And my lords, the same principle was applied by Mr. Justice Trower, which is in Authorities Bundle 4. And perhaps I'll just tab 66, and if I can do this relatively quickly. Can I just show your lordships 2 or 3 paragraphs?
Bundle 4, yeah.
Bundle 4, tab 66.
66. Univar, yeah.
So page 2156. I'm just picking up paragraph 213, second line, or first line. The present case is one in which the company relied on the decision maker's subjective intention as being to maintain the status quo, save and insofar as specific changes were necessary as a result of legislation or to reflect existing practice or otherwise specifically agree. And so your lordship can see the point. And then if we can go on to 2161. And it's in 239, 4 lines up from the bottom, where he says...
By which paragraph?
239, my lord.
239, yeah.
And perhaps, if you cast your eyes over that and just cast your eyes over to 240, to the sentence, the trustees proceeded on the basis that there were to be no changes of substance unless they were included in the schedule of changes. So that, my lords, was the first principle, which is where an existing contract is amended, if it can be shown the relevant decision makers intended only to make change X, then they didn't intend to make change Y. The second proposition, which is where X is the subject of extensive preparation and discussion and advice, change Y is likely. The absence of discussion about the other change is likely to be compelling evidence. So it's the absence of discussion point. And if I can pick that up from AB 355, which I get from FSHC and Glass, and that's at tab 55.
I'm sorry, which authorities bundle was that? I've just put it away.
Oh, I'm sorry, this is Authorities Bundle 3, my lady.
Thank you.
Sorry.
No, it's my fault.
And what bundle is it in? No. my Lord, the answer to your Lordship's question in relation to AMP, you will find in paragraph 5, and the rectification sought was of the rule changes to remove the link between ill health benefits and early leaver benefits. It's in paragraph 5, my Lord. I do apologise for not having that.
And as far as I could see, it's only spelled out at that level of generality. We don't see the actual text of the rules on the report, unless I missed something.
But even so,
That obviously was the principle which was applied in making the necessary changes.
yes. So, may I move on to FHC? FSHC?
Yeah.
Okay, so this is in Purchase Bundle 3 at 55.
Which is the first instance decision.
This is Mr. Justice Henry Carr.
Yeah.
Late Mr. Justice Henry Carr. If I just want to pick up a few points. If I could take you to paragraph 44, which is at 1676, which is the start of the discussion about absence of discussion being evidence of intention. And this sets out a submission by Mr. Wolfson, again as he then was, where it was that the very absence of any discussion can itself be the evidence the parties didn't intend it. And if you pick it up at 45, Mr. Wolfson submitted the more unexpected result X is, the more likely the court would find a common accord that it was not intended, even where it is not expressly discussed. And I pause there. We are talking about the accidental subordination, if I can, of 6 billion worth of subnotes. Mr. Howard then sought to distinguish the cases, and he submitted that in determining whether a change was intended to be made to a pension scheme, the circumstances may justify starting with an assumption the parties intended the existing version of the scheme be preserved. And he then said the change in question was never discussed at all. The absence of discussion may itself support the conclusion the parties didn't intend to make a change. Mr. Howard tried to limit the principle to the pensions cases. And Mr. Justice Henry Carr said that I accept the amendments to pension schemes raise the particular issues identified by Mr. Howard. I do not accept the principle is confined to pension cases. In my judgment, the authorities illustrate the proposition that where an important change is made to an existing arrangement between the parties, the absence of any discussion of that change may itself be evidence the parties did not intend it. Whether that is true in any case depends on all the circumstances. So what the cases show is that as a matter of evidence, to establish convincing proof of the parties' intention, it can suffice to show that the parties did not intend to effect change Y by showing that there was no mention of change Y whatsoever, particularly when change Y is a significant change. And of course, my lords, we completely accept that the weight attaching to the absence of discussion will depend on the facts of the case. However, the principle is opposite in the case of a specific amendment to a pre-existing contract. If I may just say something about PLC's position on the law. Our submission at first instance was that the absence of any discussion of the relevant changes convincing proof that there was no intention to make that change. Since the trial, my learned friend's position has moved somewhat. At trial, their position was that only a positive intention not to effect the specific change Y would suffice, but they now appear to accept that a positive intention not to effect other legal changes suffices. And if I can just give you the references, you will find that in paragraphs 75 to 84 of their skeleton argument. And if we could perhaps turn up and see one 126, paragraph 77. Yes. Which is where the point is pulled together. It's important to avoid illusion between two possibilities. And the first is a positive intention to effect change X, coupled with either a positive intention not to effect change Y, or a positive intention not to effect any other changes, which categories, of course, will include Y. This is required for rectification. The second possibility of only having a positive intention to change X and having no intention either way as to Y, i.e. being unaware or indifferent or both, was not the position in this case, but is in any event insufficient for rectification. So that is, they set out a number of categories. The first category, positive intention to effect legal change X, coupled with either a positive intention not to effect Y or positive intention not to effect other changes. And the second category being unaware or indifferent. In our submission on the facts of this case, we are in the first category, or a positive intention not to effect any other legal changes. My learned friends place a lot of reliance on Lloyd and Stanbury, and that is in Authorities Bundle 1. Well, and if I can, what I'll do, looking at the time, is if I may give you the reference and make the proposition.
Yeah, this was the boundary dispute case.
Yes, absolutely. This was Mr. Stanbury and Mr. Lloyd and plot 1428.
I'm so sorry, Mr. Phillips. Could you give me the reference again?
Oh, yes,
Authorities.
of course. It's Authorities Bundle 1, tab 6.
Thank you.
So if you'll forgive me, I won't go through the references, but I'll give you the propositions. It is not a case where there was a pre-existing framework which was being amended and there was a specific and limited purpose to the amendment. That's the first proposition, because this is an important difference between that case and this. The second point is, it was a case where the rectification claim failed on the facts because of lack of evidence from the conveyancing solicitors. In our case, the draftsman of the amended subnotes gave evidence, and his instructions are recorded in documentary evidence. PLC doubtless make a lot of the finding Mr. Lloyd was indifferent or not interested, and by analogy, that they will be submitting, I'm sure, that the Lehman Group was indifferent about subordination and relative ranking. The current case is not an indifference case, and I will come on to the so what point that the judge made in due course. Can I then take you to 4 Bundle 3, CV3, at 41 at 728, please? If I just start at 718, which is the beginning of 41, just so you can see what we're looking at. This is the subnotes. And I'm taking you to the subnotes for a completely different reason. Could we go to page 728, please? This is clause 12 of the subnotes, and it deals with modification and waiver. And the relevant parts of clause 12A are as follows. If you can go 1, 2, 3, 4, 5, 6, 7 lines down, on the left-hand side, there is the word represented and then a semicolon. And you then have the word provided, however,
Got
that.
it.
Provided, however, that certain proposals, and then you need to see what it includes, including any proposal to change any date fixed for payment of skip over principal interest in respect of the notes. And then there are some more reserved matters. And then you pick it up after the definition reserved matter may only be sanctioned, and note the word sanction, I'll come back to it, by an extraordinary resolution passed at a meeting of the note holders, at which one or more persons holding or representing not less than 2/3, or at an adjourned meeting representing any or in certain circumstances specified in the procedures memorandum not less than 1/3 of the aggregate principal amount of the outstanding notes form a quorum. And then it says this, because this is the mechanism. Any extraordinary resolution duly passed at any such meeting shall be binding on all the note holders, whether present or not. And then there is an additional provision, which is, in addition, a resolution in writing signed by or on behalf of all the note holders, who for the time being are entitled to receive notice and so on, will take effect as if it were an extraordinary resolution. So what you have got when it comes to amending the date, any change to the dates fixed for payment of interest, there is a procedure for amending by extraordinary resolution. And that extraordinary resolution is either passed, and I should have said, and it is a sanction of a proposal by extraordinary resolution. So there is a procedure whereby the note holders can sanction a proposal to amend. And that's done by extraordinary resolution, either by 2/3 or by 1/3 in certain circumstances, or a written resolution of all the note holders. It is similar to the pension cases because it is an exercise of a power of amendment. And the statement in my learned friend's skeleton argument, paragraph 107, that the sub-notes do not grant either party a unilateral power to amend, subject merely to the consent of the other, is wrong. We'll come back to this when we consider outward expression of accord. But back to...
Sorry, just unpack that a little bit. The issuer and 100% of the note holders, I would have thought, could agree any change they like. It's a contract.
It's a listed contract. I'm not sure that I'd like to...
Well, you may have to get consent from the stock exchange, perhaps. But as a matter of contract, why can't they agree whatever they like?
With respect, my lord, I would submit no, because there is a process. And the process, it actually specifically provides that certain proposals are reserved matters that can be amended in a particular way, including a resolution signed on behalf of all the note holders. And if my lord was right and said, well, as a matter of contract, you could simply amend it, you wouldn't have that provision there. This is in the same...
Yeah, but what about something that is outside these particular matters, like a change in ranking?
Well,
So
in
they
the
just
present
can't,
case,
they just can't do it, you say?
I don't think we really need to get into it, because in the present case, this is the procedure. I'm about to show you it's the procedure that was applied. But I think it's very important, because what you've got in the pension cases, what you have in all sorts of different areas of our laws, for example, schemes arrangements, CVAs, you have provisions which deem agreement if you go through certain procedural steps. Now, it matters not that on the facts of this case, it was a resolution in writing signed by 100% of the note holders. It is still by extraordinary resolution. It is still sanction of a proposal, and that is different to agreement.
Well, yes, no. I mean, the main purpose of this kind of clause is to bind people who haven't actually signed up to the amendment. It's to bind the 1/3 who didn't vote for the extraordinary resolution. It's to bind the pensioners in payment who didn't know about whatever the trustees were proposing to do, or the deferred pensioners, or whoever it was. That's what these things are basically for.
Yeah, my lord, I don't disagree, but what it means is that you don't have to have the same sort of agreement in the context of rectification, just as you don't in the pension cases. Because what you've got is you've got an amendment which is made by a process that deems agreement. And what you had in this case was sanction of a proposal.
Yeah.
You didn't have, I mean, this case has got two features to it. One is pre-existing structure, pre-existing set of arrangements between the parties. And the second is you then have a procedure whereby amendment takes place. And what you will see when we look at the process of amendment is you will see Allen and Overy drafting resolutions and producing the documents required for this process. And we cannot, in the context of what was intended, against a backdrop where you've got the pensions cases, which, albeit Mr. Howard's submission that they are unique was rejected, and I respectfully agree with that because there is a principle, but it is relevant because you didn't need the sort of agreement that you would expect, for example, if there was no agreement or if there was no process. I'm sorry. So can I then go to Supplemental Bundle 2 at tab 45?
255.
Yes, my lord. So Supplemental 2, tab 45.
45.
Yeah. And this is the written resolution that was amending the notes. And if you look at the resolution 2, SLP3 confirms that it's a registered holder of 100% of the notes and as such has sole power to assent. And again, you get the language of assent to any amendment or modification of the conditions and does hereby assent to the modification of the conditions which will henceforth be in the form attached as Annex A of the resolution. So it's assent to the amendment and the effect pursuant to condition 12, which we've just looked at, of the notes. This written resolution takes effect as if it was an extraordinary resolution as defined in the conditions. And you will see that it is signed by Emily Upton for SLP3 and by Mr. Rush for LBHI2. Then if we could go to tab 44, please. Tab 44 is the minutes of the meeting of LBHI2, and I just want to show you that it's attended by Mr. Rush. In paragraph 1, you can see the business of the meeting. They refer to the amendment, and then if you look at the last sentence, the purpose of the amendment was to allow the company to defer cash settlement of the interest on the notes at its discretion. That is a formal decision of LBHI2 that led to it signing the resolution. And then going forward 2 tabs to tab 46, no, sorry, tab 47 at page 3502. This is the minutes of the electronic consent of LB UKH Delaware, and you'll see from the third recital, the corporation is the sole general party.
No, just a minute, I'm not with you. 47 is an email chain.
47. Yes, my lord, go forward to 3502. The emails deal with sending this.
3502, yeah.
Yeah. Thank you. And if you look at the third recital, the corporation is the sole general partner of SLP2, is the sole general partner of SLP3. And then whereas, 2 down, proposed the corporation in its capacity shall approve the proposed amendment. The purpose, the final sentence, the purpose of the amendment is to allow the issuer to defer cash settlement of the interest on the notes at its discretion. The holder of the notes is SLP3. And this is signed by Mr. Triolo. The resolution is that it's approved. So those resolutions show that the purpose of the amendment was to allow the issuer to defer cash settlement of the interest on the notes at its discretion. That is the only purpose recorded in both resolutions, and that is consistent with the evidence of subjective intention provided by Ms. Dolby. Her oral evidence was she shared her intention with Mr. Rush and Mr. Triolo. And those resolutions were passed in the context of that rule. And those companies that signed the resolution were being told what the purpose of the amendments that they were assenting to was. Now, can I then just turn to the judge's findings of fact? Shall I do this? Okay. So we go back to C2 22, if we can go to 428. He dealt with his findings of fact in paragraphs, sorry, it starts at 428, 260 to 268 of the judgment. It's done in a little over 5 pages, and one of the things the learned judge did was incorporate the factual history that he'd used in relation to construction, which you find earlier at 199 to 215. And the point that we want to make at the start is that despite PLC's criticisms of the paucity of evidence before the court, there was a considerable amount of documentary evidence disclosed on all sides. There was also the oral evidence of Jackie Dolby. I'm going to show you 1 or 2 passages. She was the European tax lead with overall conduct of the amendment. The judge accepted that she coordinated the issuance of the LBHI2 subnotes, and she was very closely involved in the amendments process. And for your lordship's note, that's 213 at page 413. So responsibility for this process was with Jackie Dolby. And as we have seen, the evidence of the resolutions by which the proposed amendment was sanctioned was consistent with Ms. Dolby's evidence. And there was also oral evidence from Mr. Grant, and he was the solicitor at Allen and Overy, who had conduct of the drafting process and who received instructions from Ms. Dolby and Sarah Morrow, who was in the legal department. Now, we've set out 5 aspects of the evidence in paragraphs 80 to 88 of our skeleton. I want to focus on 3. The first is that the learned judge did not address Ms. Dolby's evidence of her own intention. She was the coordinator of the team that was responsible for the unamended notes and the amended notes. She shaped and managed the transaction and headed the cross-departmental team that worked on what was ultimately an intra-Lehman Group transaction. The judge's findings that there was no discernible intention was not consistent with the following evidence. And if you could take up Supplemental Bundle 2, tab 54. And I would like, I'm sorry to be jumping from one bundle to another. I would like to start at 5, 6, 7. and this is on day 3, page 110. It's on the bottom left-hand quadrant. If I could take you to 13 to 18, the question, and the reason for that is, as you have explained, is that all you intended was that the interest should be deferred or could be deferred to achieve the tax benefit that you very helpfully described. And that's right, isn't it? Yes. And then at page 570, on page 131 of the transcript, on the top right-hand quadrant, and it starts at line 10, and all you intended was that the interest could be deferred so that you would achieve the tax benefit that you have been describing to his lordship. That's right, isn't it? That's correct.
Sorry, could you give me the page reference again for that?
I'm so sorry, it's at 570, lady.
Yes, and internally.
Internally 131, it's the top right-hand quadrant, starting at letter 10.
Thank you.
Number 10.
Thank you.
And then if I could go to 571 over to 572, this is starting on page 135 of the transcript in the top right-hand quadrant at 19. And both Mr. Rush and Mr. Triolo, who we have seen were tax people who were familiar with the transaction, correct. And they both understood that the intention behind the transaction was to defer interest for the tax benefit you've described, correct? Correct. And both Mr. Rush and Mr. Triolo would have known that was the purpose of the transaction, yes? Yes. And all you intended was that the interest should be deferred to achieve that tax benefit. You didn't have any additional intention than that, did you? No, not from a tax perspective, no. Mr. Rush approved the 2008 amendments on behalf of LBHI2, yes. We have seen that. And you have explained to his lordship that you and he had a close working relationship in which you discussed all of these issues beforehand. That's right, isn't it? Correct. And he shared the intention that you had, which was to defer the payment of interest for that tax benefit. That's right, isn't it? Correct. And you did not discuss ranking or alteration with Mr. Rush. That's right? Yes. And we've seen that the Delaware consent did not mention any other purpose or intention. We've seen that. Yes. And Mr. Triolo would have shared the same intention because he was a taxman in the US. That's right, isn't it? Correct. Second, the judge said the history of the draft amendments or any of the draft communications or discussions with the Lehman Group were not material. And for your notes, that's paragraph 211. That the history of the draft amendments shows that the only change the parties' legal to the parties' legal rights and obligations intended by the amendments was the deferral of interest. Now, we set this out in our rectification chronology, which, if you want to look at it, is at Supplemental Bundle 1, tab 12.
Sorry. 211 is dealing with the interpretation, isn't he, of the amended notes. He's not there dealing with rectification. I mean, I take your point that what he should have done is gone back over what he said was or wasn't relevant. But in terms of, in its own terms, there's nothing wrong with 211 as regards the interpretation of the amended notes.
Yes, but I'm so sorry, my Lord. What the learned judge did is he incorporated these paragraphs into his rectification.
Yeah, so that's your criticism.
And I'm only criticising this for the purposes of rectification. Only, my Lord, where the learned judge says, I simply do not consider it material. And in the context of rectification, we respectfully disagree. Yeah. My Lord, your Lord's absolutely right in the context of construction. So, yes. So can I show you first, if you could take out Supplemental Bundle 2, and if I could take you to tab 29. and I'm not going to show you all of them at tab 29, page 445. This is an email of the 11th of June, the top email from Jackie Dolby, that is sent to, amongst others, Sarah McMorrow, Emily Upton and others, and it talks about the amendments. And it says, we're looking to amend the terms of the QEB issued by Intermediate 2 last year and currently held by SLP 3. The change will give flexibility to allow the deferral of actual cash settlement of the interest, though the interest will continue to accrue in both parties' accounting records and will ultimately be cash settled. My view is that the board of both companies, or the GP in the case of SLP3, should have a quick board meeting to ratify this. Thoughts? Question mark. Then, if we could go forward to tab 31 and at page 448. This is an email of the 12th of June from Mr. Grant of Allen and Avery to Jackie Dolby, Sarah McMorrow and others. And he sent the second draft of the amendment to Ms. Dolby and her team in the Lehman Group. He also sent a draft of the written resolution of LBHI2 approving the amendments. And the covering email refers to, you can see, the centre, a composition showing the changes since the last draft you saw. Deferral provisions introduce tax sensitivities. The amendments are designed to ensure these sensitivities are met. And so the amendment was flagged as a means of preserving the subsisting tax treatment of the notes. And then if I could perhaps just go to...
This refers to the entirety of the amendments.
This refers to Mr. Dehal's tax concern.
So Allen and Avery are saying to Lehman's, not only have we deferred interest, we've done this other thing as well because tax sensitivities were involved.
Introduce tax sensitivities. Yeah, and what he says is the amendments are designed to ensure these sensitivities are met. And what it doesn't say is, by the way, while we're at it,
I understand that.
Absolutely. And if I can just show you, Lordship, SB1, at tab 1, page 21. This is Mr. Grant's witness statement.
Sorry, SB1.
SB1, tab 1, and
Tab 1.
it's page 21. I just wanted to show you paragraph 58. And in paragraph 58, Mr. Grant says, as part of the amendments to the subnotes, I drafted the written resolutions for LBHI2 and SLP3. I emailed drafts to Ms. Dolby, so he's referring to this email. The written resolutions state the purpose of the amendment was to allow LBHI2 to defer payments of interest on notes at its discretion. I did not refer to the amendments to the subordination clause. They were introduced solely to clarify the tax position and not to make a substantive change to the parties' rights to payment. And the point that you've seen from the email is the email did not flag any changes to the legal relationship. And then SB2 again, tab 30, page 446. I should explain what this is. As part of the process, the Lehman Group procured several documents from Allen and Avery, and this included a corporate benefit note of the 12th of June, which is this. And you can see that the subject is corporate benefit.
Yeah, this was referred to in the email you just showed us, I think, wasn't it?
Absolutely right, Lord. And the amendment, you can see, the amendment involves changing the terms and conditions of the notes to allow the issuer to defer payment of interest on the notes. the issuer and the sole holder of the notes, SLP2, will approve the amendment by a written resolution. The note holder in approving the amendment will be agreeing that interest payments may not be made on interest payment date as currently set out. And there was no mention of ranking changes. And as we will show you in a moment, Miss Dolby accepted in her evidence that a ranking alteration would have been to the corporate disbenefit of SLP3, and that SLP3 should have been notified of and agreed to it. But I'll show you that in a minute. Finally, once the drafting was finalised, you've seen how the amended notes were approved and signed off. If I can just show you emails, go forward in SB2 to tab 43, please. This is on the SLP3 side, and it's Mr. Harold Dave, who was a lawyer to Mr. Triolo, and he says this, top paragraph, Jackie has been looking at amending the terms of the note issued by LBHI2 to Lehman Brothers to SLP3. The change will allow LBHI2 to defer payment to SLP3 under the note. I attached the relevant document. I'm not sure of the extent to which you've discussed it with Jackie. Happy to arrange a call. And if I can then go on over to just remind you, 44 is then the resolution that is signed. And you've then seen the board minutes. But the point that I'm making, perhaps too laboriously, is that the purpose of these amendments was made clear and was understood as such by all involved, that it was just to defer the interest. And the extent to which there were other amendments to deal with tax sensitivities. Oh, yes, I'm sorry. Mr. Wilson reminds me that the email we were just looking at did not attach the amended notes. Mr. Triolo himself did not see the amended notes we just looked at. So yes, so you've seen the fact that intention X absolutely spelt out, discussed by everybody right through the process. Intention Y, the evidence you've got is that if there had been such an intention, actually I haven't got to those bits yet. If there had been such an intention, there is other evidence, which I haven't shown you, that they would have expected it to have been raised. But what Mr. Grant says in his evidence is that he was intending to maintain the status quo. He wasn't intending to make any other substantive amendments.
I think Ms. Dolby's evidence was that if the point had been flagged, it would have been discussed. Don't think she said she would have been rejected. She said it would have been discussed.
She said that if there had been such a change, she would have expected it to have been raised with her, and she would have discussed it. Mr. Grant's evidence was he would have expected to raise it with her.
But Mr. Phillips, you did show us, I think it was an email or some correspondence from Mr. Grant, which said, in effect, and there's wording which deals with the tax sensitivities,
Yes.
which was a reference to the extra, the Mr. DeHaal point, let's put it that way. Yeah. And so they were aware that there was extra wording that they were signing up to.
They were aware there was extra wording, and they were told that extra wording was there to deal with a tax sensitivity that had arisen, not to alter the subordination. And the other thing, my lady, that of course we've seen is the corporate benefit note. And the fact is that if SLP3 had been subordinated by these amendments, that is a significant corporate disbenefit of 6 billion worth of notes being subordinated. And that was not referred to in the corporate benefit note. Again, all that you see in the corporate benefit note is the description of the intended amendment. And yes, and in that email, Malone, he talks about preserving the tax position. He's not talking about making any other legal changes. He's doing something to preserve the tax position. I can see, my lord, that you're...
But no, I'm sorry, I'm reflecting. And there are very fine distinctions in these areas between positively wishing to make no change and accepting a change without having any particular feelings one way or the other as to how far it goes or what it entails.
But it's...
We do know here there were tax sensitivities which had to be catered for. Nobody seems to have asked for chapter and verses precisely how that was being done, but equally they were all happy to sign up to the text that was enclosed by Mr. Grant with his email. Is that enough for your purposes?
Yes.
That's a big question.
No, my lord, the reason why I say yes is this. You have got, if I may put it, you've got clear evidence that everyone involved in this process intended Amendment Y. And you have got the evidence you've got in relation, sorry, Amendment X, and the only evidence you've got in relation to Amendment Y is there are some tax sensitivities, but we are preserving them. What you have not got anywhere is any indication of an intention to alter the ranking at all. And you have got evidence that if they'd wanted to alter the ranking, they would have discussed it. And it would have been important. And remember, sorry, when one goes back, I think it was at AMP where they said the more important the amendment, the more unlikely it is that it would have been intended when it's not been discussed. And the other point you get is that the more Amendment X is discussed, the less likely it is that Amendment Y is being intended.
But just to leave aside amendment for the moment, because I understand that there are some special points which you, you want to rectify the contract, I suppose. The first thing you do is to look at the contract and decide what it means. And you don't have to have evidence that parties intended it to mean that. It just means what it means. If they want to rectify it, they've got to show you positive evidence. They didn't want it to mean that. So to say there's no positive evidence that they wanted this change or another change, does that really help you on the question of rectification? What you need is positive evidence that they didn't want to make the change.
Well, with respect, my lord, you do not have...
You say you've got that, but I think you were answering Lord Justice Henderson in saying that there needed to be evidence that they did want to make the change, but there doesn't. The change is the change, as it appears in the amended notes.
I'm sorry, my lord. We do not have to show positive evidence that they did not want to change Y. What if you go back to those categories that we see that we saw early on in the discussion? All we need is an intention to make change X and not to make any other legal
I'm not sure
changes
about that. The lack of evidence is material from which you can infer an intention not to make change Y.
But we've got evidence.
Well, I follow, but then it's a question of inference from the evidence.
Yeah. On any view, one of the things you did intend to do was to make the necessary changes to prevent the tax sensitivities which had arisen. And nobody seems to have really bottomed out precisely how that was to be achieved. And in that situation, are you not left with the consequences of what you objectively chose to do, which was to undertake that, as it were, that second phase, as well as the initial phase of deferment?
My answer to that would be no, when you look at what those resolutions said. Because I completely understand, my lord, where you're coming from if we were dealing with an ordinary contract. And we are just not dealing with an ordinary contract. We're dealing with something that can be amended by mechanism.
All right.
Yeah.
Now, I do notice the timetable reports to alive till 4:30. Normally we rise at 4:15, but I think today we will alive till 4:30. but perhaps your colleagues can bear in mind our normal rising time in the afternoon is 4:15.
Well, my lords, could I perhaps make the third and final point on this part, and then if I could take 15 minutes from my reply submissions in due course tomorrow morning just to finish off rectification.
Well, right. Well, as long as you and Mr. Beltrami agree the timetable, that's fine.
Well, if my learned friend will kindly just give me 15 minutes tomorrow, and I promise I'll take it off my reply.
Well, of course, I've taken that undertaking that will come off as a reply, so I'm very
I'm obliged. So if I may just do this one last
Yes.
point, and then I'll have a look at what's left this evening. If I may. The third point was that the judge did not engage with the nature and scope of the instructions that were given by the Lehman Group to the drafting team. And as your lordships know, the instructions were given to Mr. Grant, and he agreed that the only change he was asked to make related to deferral of evidence. And if I could take you back to, deferral of interest, if I could take you back to SB 251.
Does this really take the matter very much further forwards when we've got that further email from Mr. Grant later saying, and we've also catered for this other point, and I know what that says, and we've discussed that already. So what the original instructions are doesn't really help a lot, or has no more weight than you've already given them.
My lady, yes, I don't disagree. Well, can I just give you the references so that perhaps if you're interested, you can look up what Mr. Grant said in his evidence. The first reference is in SB 251 at 549, which is day 2, page 124, 10 to 21. And the second reference, which is a reference I've already referred to, is at SB 252 at 552, and that was day 2, page 139, 8 to 11. He agreed that if the effect of the amendments had been that the sub-debt took precedence over the sub-notes, he would have told Miss McMorrin would have needed to take instructions. Just for your note, the final reference is Miss Dolby. She was interviewed, and she then said that that's all A&O were instructed to do, and you'll find that in SB 1453 and 57. Those references. And the particular point that you will find there is that she said they were not instructed in relation to preserving the tax deductibility. PwC were doing that. PwC were dealing with tax issues and giving extensive tax advice. Dealing with that was too loose. So, my lords, if I may draw stumps at that point. Oh, no, I can't draw stumps. Hang on. Hang on. I'm not the 12th man. Oh, I'm so sorry, my lord. I have until 4:30, as I understand it. So, if I may.
Yeah.
Right. The next item on the agenda is turning to the intention of LBHI2, and then I'll turn to the intention of SLP3. And you've seen the board resolutions, you've seen the background material. If I could take you to the judgment at C2 22 429. This is paragraph 262. And if I can just pick it up in the second line where the learned judge says, I can see no evidence of any intention going beyond the objective construction of the notes as to how the notes of subordinated debt should rank as against other subordinated debt issued by LBHO2. Indeed, such evidence as there was before me strongly pointed to this being a matter that simply was not considered by LBHI2 at all. And with respect, we say that misses the point, because the question wasn't what positive intention there was on relative ranking. The sole intention, as you have seen, was to alter the payment date of the interest. And you've seen the exchange that my lady referred to earlier in relation to, if I can call it the DeHal point. But there was no intention to make any other change. So even if we were saying, well, intention X is the tax deferral of interest plus DeHal, there was no intention to make any other legal change. And that's what you can see on the evidence. So even if you were pushing me back on that, I would still have that fundamental point that subordination, the changing of ranking, is a fundamental change. It's a major change. With no intention to alter the ranking, of course, it's hardly surprising that there was no discussion about relative ranking of the notes or the debt at the time. And in our submission, for the reasons we've explained, the absence of discussion of relative ranking is a point that supports our case, and it's certainly not a point against us. So there were several other flaws that I just want to draw attention to. First, the judge said, and if you'll note that's 262.1, that there was no evidence that anyone in the Lehman Group gave thought to subordination between different subordinated obligations, because they gave no thought to insolvency. He said they didn't think about subordination because they gave no thought to insolvency. But with respect, that doesn't follow. And you've seen subordination is relevant both in a solvent situation and an insolvent situation. You can see that from Standard Form 10, which deals with both. And the amendment to Condition 3, of course, itself bifurcated the subordination mechanism so that it contains separate provisions for subordination in insolvency and in solvency.
Well, why do you say that? If the borrower is solvent, then everybody gets paid. So why should they worry about subordination?
Well, there are all sorts of reasons commercially why they worry about it, and I don't want to try and give expert evidence, but this debt wasn't traded. But if you can imagine subordinated debt that is traded, where you are in the level is one of the relevant factors. So the point that I'm making here is that the learned judge oversimplified this point by saying that the reason why they didn't think about it is that they didn't think about insolvency. And the second point...
Well, nor did they think about sending the debt outside the group, did they?
No, they didn't. But your lordship shouldn't confuse the 2 points, because there was evidence from Mr. Katz's team in relation to the dividend stopper that they did think about relative subordination in relation to that part of the structure that was sold outside. So it's wrong to say you don't think about relative subordination unless you are in an insolvency.
Yeah.
The second point was, and this is in 262.4, and I should just make it clear, of course, Katz's evidence about what the discussion was rightly rejected, but it's the fact of the discussion. In 4, it's not clear, he says, he concluded that even if the relevant individuals within Lehman Group had been told about the ranking alteration, they would not have cared. They would, and this is in 264.4d, where he says it's not the point. The point is that no one focused on the question of relative subordination. The point wasn't raised. That fact provides significant thought into what would have happened had the point been raised. In my judgment, and of course the question is a hypothetical one, had the question been raised, it would have been met with a resounding "so what?" He says that it would have been a matter of indifference. But with respect, that misunderstands the evidence of Mr. Dolby and Mr. Grant that you have seen. Because Miss Dolby said that if she'd been told that the sub-debt would take priority over the subnet, she would likely have discussed the situation with her legal and regulatory colleagues. That was her evidence. And she did not have such a discussion. And in 262.4a, you can see that extract from Miss Dolby's witness statement. And in 262.4b, the judge set out an extract from Miss Dolby's cross-examination, which he accepted as true. And she said she hoped she would have discussed a change in priority with colleagues, and it was unlikely she would have signed off without any discussion. If you look, you see that I asked the question, you would have discussed it with your legal and regulatory colleagues. Yes, it might have created the other guys in the team in other departments problem, I don't know. You would discuss it with them, I would have hoped to have discussed it with them, and so on. So it wouldn't have been met with a so what. And that was also confirmed in her witness statement, which is, I'm just looking at the time. Yeah, I'm so sorry. I don't think I should take up any more of your time this evening. That's not right.
All right.
May we draw stumps as I did earlier?
All right. Thank you very much, Mr. Phillips. We'll start again at 10:30.
All right.